Right, I'd like to welcome everyone to this MGAA market briefing, and yes, a big thank you to everyone. I think we've got quite a lot of people joining us, so a very popular topic. So before we get started, I have some little housekeeping to do, and apologise to anyone who is a frequent attendee at these because the content doesn't change. But so start off with what we'd politely ask you not to do during the presentation. So to help us stay with you for the duration and not have any technical hiccups, if I could ask please for cameras and microphones to be kept off. The other thing to politely request is that if you have activated any AI note-taking tools, please can you deactivate them, purely because we need permission of everyone attending and we don't have that. So if you have activated them, if you could turn them off, or if I see any, unfortunately I will step in and remove them from the meeting. So that's all the don'ts over and done with. The next bit is nice. We're moving into a positive area now. So yes, questions. So the team from HF are very welcoming and encouraging of questions during the presentation. So if you can pop those in the chat as we go through, that would be great, and then we'll cover them at the end of the session. So yeah, so that's all my instructions over and done with. Just a few bits and pieces about the actual session. So just to let you know, I think Zoom has already let you know that it's being recorded. The good news for that is that means that a copy of this will be available if you want to review anything. And also, if you have any colleagues that you think it will be of interest to, you'll get a link to it, but it will also be in our on-demand section of the website. And last thing, just to remind you that our market briefings are accredited by the CII for CPD purposes. So this fits with your development needs. You can record it on your CPD log. So that's my intro and housekeeping completed, and move on to the session. So today is legal expenses, a ticket to ride, which is delivered by HF, and very happy to welcome Gordon Walker and his colleagues. I said Rachel, sorry, I nearly called you Rebecca. Rachel and Peter. So I'll hand over to Gordon to do the proper intro and get underway.
Thank you very much. Thank you for listening to us today. It's a pleasure for us to be with you. Some of you will be sophisticated providers of legal expenses products. Others may be dealing with claims funded by legal expenses. And hopefully today we'll have something useful for all of us. At the start of this talk, it's useful for us just to hit some learning objectives from today. We're going to look at both BT and AT and their differences, as well as the role of funders in the general area of providing access to justice through funding and LEI. We'll have a short tour of how we got to where we are today, and also look at some of what we think may be classed as possible problem areas for LEI products. And we'll look at the recent CJC report into funding. That last topic is a large topic on its own, and we could talk about it probably for another hour at least. But we're not going to do that. We'll give you a summary of the most pertinent points that we think have arisen from that report that affect the future of this whole topic. I hope today we'll leave you with a few earworms. Let's see how many of you remember the lyrics and the tune to Ticket to Ride by the Beatles. So just moving on to the welcome slide. First of all, I'd like to introduce you to my fellow speakers, both to Peter and Rachel. So Rachel, would you like to just quickly introduce yourself?
Hello, my name's Rachel Quinn. I am a solicitor at HF in the London Markets and Specialty team.
And Peter?
Good afternoon, everyone, and thank you for joining us today. My name is Peter Olympius. I'm an associate partner in the London Market and Specialty team here at Horwich Farrelly. I specialise in professional indemnity defence work as well as marine claims, including policy coverage advice. And I will predominantly be talking about the CJC's recent report and their key recommendations in relation to litigation funding today. Back over to you, Gordon.
And last and very much least, I'm a partner and the head of professional indemnity and financial lines in the London Market Specialty team at Horwich Farrelly, and specialise in professional indemnity, general insurance and policy advice. So that's the three of us. Let's crack on. So why is legal expenses an increasingly relevant topic for MGAs? Well, the MGA market is agile and reactive, capable of sustaining a wide range of products and a variety of approaches within a product area. And this is a crucial attribute for the area of legal expenses. Legal expenses itself is an increasingly agile and sophisticated product. It's responsive to many needs, to the needs of those who wish to fund smaller size cases, but cases that are of supreme importance to them both personally or in business, and also the needs of the more sophisticated commercial entities who wish to ameliorate the risk, the inherent risk of litigation. So this topic should be of interest to a wider audience also that don't write legal expenses, but maybe the recipient of claims funded by legal expenses or funding. It's important to understand how effective these solutions are and the effect they have on access to the courts and on the strategy and tactics of claim. We already referred to a ticket to ride. So who gets a ticket to ride? Is that what legal expenses and funding are? Well, claimants using legal expenses, they certainly get a ticket to ride, but how much of a ticket and what is it a ride to? Defendants, they need to understand what ticket the claimants have to enable them to set strategy on claims. And I think overall, from today, it's important to understand that legal expenses and funding can inject more certainty into litigation, and a balanced view of strategy and risk, especially at a time when the courts are stressing the importance of ADR. That must be a good thing for all. So let's start our tour of the roots of legal expenses and a review of some of the interesting differentials between products and the way the future may unfold. First of all, let's look at how did we get here. I think I'm going to be sad. I think it's today. I put a question mark in that lyric because I wanted to think whether we are in a good place or a bad place with the development of these products. But first of all, I'm going to ask Rachel to give us a little thumbnail sketch of some of the back history to legal expenses and how it first started. But Rachel, over to you.
Thank you, Gordon. One of the early forerunners of offering cover for legal expenses was formed after a professional incident in 1897 involving a doctor in Paris. A woman he had attended died in childbirth, a then quite frequent event, but the deceased husband hauled the doctor before the courts, where he was found guilty of negligence or incompetence and sentenced. An organisation providing mutual assistance for health professionals, Le Concours Médical, followed the case, and its managers used it as a starting point for setting up a mutual company to protect members involved in similar occurrences. This company, still in business in the fields of LEI and professional liability, was called Le Sourd Médical because the membership fee was 5 centimes per day, or 18 francs per year. At that time, sensitivity to cases of malpractice in the health field was nothing like it is today, and far from being compulsory. Before automobile civil liability insurance became compulsory in France in 1959 and later in other European countries, in December 1917, a 50-year-old entrepreneur in Le Mans, who was an enthusiast for motor cars, set up the Automobile Club de l'Ouest. He organised the first legal protection insurance service for club members, which was ready to defend them for the complications of being a road user. It was so successful that it threw the club's organisation and finances into crisis. From then on, the service could no longer be provided for everyone. Only those who paid a contribution to a mutual company set up for the purpose. This was La Défense Automobile et Sportive, or DAS. For nearly 40 years, from the end of the 1940s, the primary form of litigation funding in England and Wales was civil legal aid. From the start of the 1980s, however, there's been a steady withdrawal from that model. Successive governments have reduced the amount of public funds committed to civil legal aid to the lowest level possible, while also removing significant areas of law from its scope.
Thank you, Rachel. I love that bit, and now I understand how DAS got its name, which is great. I want to just talk for a minute about champathy. This is a legal doctrine, sometimes referred to maintenance and champathy, which provides that unconnected third parties assisting litigation by providing financial assistance shouldn't be allowed to do so, especially if they've got an interest in the outcome of those proceedings. Champathy seems to be diametrically opposed to the existence of legal expenses and funding, and there was a real fear that a third party could manipulate the litigation process. As Lord Denning put it, they could be tempted for their own personal gain to inflame the damages, to suppress evidence, or to even suborn witnesses. And that's still reflected in some of the CJC reforms. We see requirements that funders should not be able to influence the way that the litigation is carried out. But now that view has somewhat changed. And in 2013, Lord Neuberger, who was president of the UK Supreme Court, said that access to the courts is a right, and the state should not stand in the way of individuals availing themselves of that right. So some exceptions to those old rules are allowed, and we're allowed to look at and experience and explore the virtues of legal expenses and funding. But before then, there was civil legal aid. And not many of us on this call perhaps remember how it worked. Sadly, I do. I recall completing many a green form for initial advice and submitting claims for legal aid on full-blown litigation. And as I recall, there weren't too many refusals. In some respect, a recipient of legal aid was in a better position than a privately funded litigant, and the legal aid charge that was applied was not always a huge deterrent. Then legal aid started to be abolished in civil proceedings, and the Access to Justice Act in 1999 ushered in a new dawn for legal expenses. Legal expenses was born a bit like Frankenstein was born, put together to respond to a need in the litigation world. Some 7 years later, in a case about recoverability of AT premiums called Rogers and Merthyr Tydfil County Council, Lord Justice Smith added a personal postscript to that judgment. And in that postscript, he made some interesting observations, and I'm going to summarise them. He spoke about the changes in small-level personal injury cases that he'd seen as civil legal aid disappeared and funding took precedence. Underwriting evidence given in the case showed that 70% of small personal injury cases that went to trial failed. And Lord Justice Smith said he felt that was because of a lack of robust advice, because people could just go to trial and not worry. In the past, he said, he'd been shocked at how many obviously difficult or weak cases were proceeding to trial with the support of legal aid and were being lost. And he asked, is it any better now that we have legal expenses? He said that cases with only 51% chance of success receive legal expense insurance, and he wondered if that was the right way to approach things. He said the figures they'd seen in the case suggested that AT insurance market was not managing at all well, at least on cases that go to trial. Is that how we feel today? Well, let's see. We'll come back to that later. Now I'd like to take us through a review generally of the differences and the covers of BT, AT and litigation funding. As we're doing that, I think it's worth considering whether or not we think they do in fact provide a potentially 360-degree solution for funding needs in the litigation cycle. Let's start with BTE covers. After the demise of civil litigation and legal aid, insurers recognised the potential for this cover, hence the start of the BTE policy. It's a policy that's designed to be bought at a time when most people don't think they need it. They haven't got legal proceedings or the threat of them, and they buy it often as an add-on to a property cover, not a standalone cover. It covers typical areas of litigation. Sometimes they're restricted: employment, contract disputes, professional indemnity, regulatory matters, and excludes others where the product really wouldn't work. Awards of costs are covered, and own costs can also sometimes be covered. And so it is a bit of a ticket to ride, but not to ride everything. The policy will provide that the insured must have reasonable prospects of success in the proceedings before cover will be provided. And some policies require the case to be assessed by counsel to determine the likelihood of a successful outcome. There are also notification requirements that place a burden on the insured to comply with conditions to make sure their claim gets covered. How different is ATE? Well, ATE is taken out after a dispute has arisen to meet the legal costs of those proceedings. It covers awards of costs, the insured's own costs if they have a CFA in place. There are structured premiums often, and anti-avoidance endorsements, which are important for security for costs. There may be cover for some of the insured's disbursements, but maybe not all. Again, that's just part of the agility of the cover. Stage premiums are often applied, which get higher the closer we get to a trial, when of course the risk is crystallizing or increasing. Sometimes if the claim is successful, a deferred premium may be applied. The anti-avoidance endorsements are important. As we all know, insurance policies do not always provide indemnity because the insured may not comply with all the conditions applicable to the contract of insurance. To avoid this being a bar to being able to use ATE cover as a weapon to defeat a security for cost application, ATE policies often have what is referred to as anti-avoidance endorsements. These endorsements will prevent the insurer from rescinding, cancelling or avoiding the policy, except in cases of fraud or deliberate breaches of the duty of fair presentation. These clauses need to be drafted very carefully to make sure that they're effective. The suitability of an ATE policy as security will depend on the likelihood of avoidance and the extent of the cover provided. So both covers are similar, but ATE may be described as perhaps more laser focused. BTE has a potentially wider range of focus and has even more reliance on conditions for cover. And both products seem to cover the needs for the access to justice over a potential range of claims and claimant circumstances. Of course, we're not in a position anymore where success fees, etc., are reclaimable. That stopped in 2013, so that's not a relevant point for us to consider, but worth mentioning because it is part of the history of the product. Just turning to litigation funding, look at some of the key points of these covers. Funding is available to cover all costs and disbursements usually under a budget, an agreed budget, and this funding is not provided by insurers. It involves commercial entities. It's flexible. It's possible to cover a limited selection of disbursements only if that's necessary. And until PACCAR, success fees from damages were applicable. We're going to see more about that later. Budgeting of a claim is crucial to make ATE work effectively between both the solicitor and the insurer. Sometimes private equity look to use funding to monetize and de-risk claims in portfolios. And it's also a hugely beneficial tool in class actions where claimants could not afford to finance smaller claims on their own. The risk consideration for funders are paramount. What's the budget? What's the level of potential damages? And what are the prospects of success? So funding has been something that's been provided by non-insurers aiming to meet the needs of upper-level claims and multi-party claims to which ATE may struggle and BTE may struggle to meet. One of the questions posed by funding seems to be how much legal funding might expand from its pre-PACCAR space and before PACCAR, how much lower down the claims food chain they may move. And then we had PACCAR. Peter's going to explain all that to us later, but just to give a slight bit of background, until PACCAR versus the Rail Haulage Association, there was always a consensus within the funding community that funding agreements were not damage-based agreements. However, the Supreme Court decided this was not the case and that agreements would only be enforceable if they met with the appropriate strict regulations on damage-based agreements, and most did not do so. Peter will deal with the chaos that brought about in due course. But the funding industry is nothing but ingenious, and to get around PACCAR, they looked at different ways of approaching cases. Peter will talk about another particular one about how they assessed multiples of the amount of cover as their way of assessing a success fee, if you like. But also we saw a slight increase in the use of WIP protection, capital protection and judgment preservation policies, all which go some way to helping the funding of litigation. So that's a quick tour of the products available and their core constituent parts. Until PACCAR, it did seem that the provision of legal expenses and funding was going quite a long way down the path to achieving better access for justice. Of course, achieving that can only be done if the market is regulated correctly. So it's worth looking at the regulation of both LEI and funding. To quote the Beatles, she ought to think twice. She ought to do right by me. So does, in fact, the regulatory environment do right by both products and by the access to justice? Well, legal expenses is regulated by the insurance company's legal expenses insurance regulations, which enshrine rules as to conflicts and the right to choose your own lawyer. By the FCA, using customer duty and customers being treated fairly. The Legal Services Board has a strategic role in promoting access to justice and just recently calls for greater public awareness of the product. And FOS, our friends at FOS, who handle complaints from consumers about legal expenses. And what kind of complaints do we see going to FOS? Well, complaints about the prospects of success. Interestingly, FOS takes the view that insurers have to assess prospects on the information available at the time. So if a case later succeeds, it doesn't mean that the earlier decision of being under 51% was necessarily wrong. There are complaints about freedom to choose lawyers. FOS will often support insureds, especially in complex or specialist areas, to get the lawyers that they want. And they'll certainly support insureds if there's an insistence on paying a ridiculously low rates, hourly rates, which means there's no real choice for the insured. Complaints about the timings of covered events, which whether they are written in policies that are claims occurring or claims made, and how those policies should respond, gives rise to some complaints. There's some complaints about policy terms generally, where they are ambiguous or unclear. And there's complaints about claims handling. Complaints don't just arise because of decisions to decline funding in that respect. Over the years, the data shows that about 43% of complaints were from claims handling and 40% related to assessing the prospects of success. Now, the good news is that legal expense referrals seem to have a slightly lower uphold rate than further covers, 22%, as opposed to an overall figure of 32%. And of course, legal expenses insurers are going to be liable to fair value assessments and the new regime of consumer duty, which we've already discussed above. What about funders regulation? Well, all we can talk about is what the regulation is to date because of the recommendations of the CJC report. So far, regulation has been done by an independent body set up by the Ministry of Justice to deliver self-regulation, the Association of Litigation Funders. And they have various requirements such as access to capital, as opposed to having to raise funds, adequacy of capital at all times, and how termination and approval of settlements is done, which must be done reasonably, and with agreements only being terminated in very limited circumstances, and also regulations about not taking over the control of litigation, Chamberty raising its ugly head again. How much is all this regulation likely to be changed by the CJC report on funding? Well, that's something, again, that Peter will touch on in due course. I think that regulation to date seems to be responding to the need to protect customers and small businesses as far as BT and AT are concerned, and to allow funders some room for agility in the provision of funding, at least until PACCAR. Prior to the CJC, the market looked likely to stall because of PACCAR and rely on the ingenuity of funders to find ways around it. And again, we'll see that that's also being put into doubt. So let's look at real-world claims and common pitfalls. We want to just look at some of the provisions in legal expenses policies which worth considering to how the market might develop in really what's a potential watershed time for the whole legal expenses and funding world after the CJC report. So she said that living with me was bringing her down. Are restrictions that are imposed by AT and BT making it a more difficult product to live with? And how do we deal with PACCAR? Let's look at notification clauses to start with. In the case of policies written on a claims-made basis, the cause of the claim has to be notified, usually immediately, that the insured becomes aware of any cause or event or circumstance which has or is likely to give rise to a claim. Of course, wordings vary from policy to policy. In the case of a claim being used for the defence, of a matter, then again, the insured must be aware of the likelihood of being sued and be able to notify that at the appropriate time. Both those decisions are difficult for insured to make and often quite hard to assess, even applying the test of what a reasonable person reaching such a conclusion might do. If the policy is written on a claims occurring basis, then of course the insured's got to work out which policy would respond to the event occurring. When did that event occur? And again, that might be a very complex decision to interpret. So notification clauses need to be clear so that insureds can know their position and the basis upon which the policy works. And that needs to be explained to them clearly both in the wording and in any pre-purchase communications. If anybody's got sleepless nights, they want to read the case of Lake Event and Templeton, which is a good example of the difficulties that the court can encounter in these circumstances, although they came to a very sensible conclusion. I think it's important, if we're going to maintain a growing market for insureds, that they must have confidence in these products. They have to be easy to access and to understand. And getting simplified wordings and accessible wordings that still protect insurers' position is absolutely crucial. What about the prospects of success rule? Well, the prospects of success rule means that legal actions must demonstrate a reasonable prospect of success. And that's generally interpreted as having at least 51% chance of succeeding in court. If an insurer determines the claim does not meet this threshold, then they may refuse to fund the action. When the policyholder files a claim, the insurer assesses the prospect of success, sometimes by referring to the insured's own lawyers or to panel solicitors for an evaluation of the prospects. And if the solicitors indicate a less than 51% chance of success, using more likely than not standard, the insurer may deny coverage. Well, how does one really assess the chances of success? Now, the civil legal aid criteria in 2013 provided that a moderate chance of success was 50% of obtaining a successful outcome, whereas below 51% was regarded as marginal or poor. And in Rogers versus Merthyr Tydfil Borough Council, the court said that any case that was going to trial with a denial of liability could only just be over 51%. I think it's clear from looking at those two rather contrasting approaches that the prospect of success is something that depends on each individual case and on the strength of the legal position as well as the strength of witnesses and expert witness evidence. One of the problems with prospects of success is that the perceived chances of success may evolve as new evidence surfaces or as the legal proceedings unfold. And so ongoing assessments may be necessary, with the possibility of the insurer withdrawing support if prospects diminish. It's vital for policyholders to provide any new or relevant information that could strengthen their cases. And there's also the inherent problem of a solicitor having to say when prospects have worsened. Now there's a potential conflict situation if ever I saw one. Does the 51% rule make sense, and does it support access to justice? Well, I think it makes very good underwriting sense, and I think probably yes, it does support access to justice, because funding weak cases is not in anyone's interest. But the method of assessment needs to be as clear as possible. We note the large number of FOS complaints that arise from this. So I think policies need to have clear requirements for the assessment of prospects of success, and at what stages this assessment has to be done. To make it clear that there'll be regular assessments of this to take account of changing circumstances as the case unfolds and obtaining proper reports from solicitors as to what's going on. What about choice of solicitors? Well, generally policies will provide for the use of panel lawyers. This often gives rise to problems, especially when claimants have already been using their own solicitors before the possibility of BT cover, for instance, is discovered. The problem was considered in a case called Brown Quinn versus the Equity Syndicate in 2012. And the basic tenet that they were dealing with was, of course, freedom of choice originating in the EEC regulations. However, the court took the line, this provision was only breached if it were impossible for the insured to choose their own lawyers. And the word impossible is what's important. The court decided that the insured could use their own lawyers, but the insurer only had to pay them their prescribed non-panel rates. To allow an insured to choose whoever they want at any rate isn't a prerequisite to access to justice, but the Brown-Quinn decision is pragmatic. Insurers only need to set panel and non-panel rates at levels that do not interfere with the freedom of choice. And of course, reasonable premiums are a huge factor in access to justice, so allowing an unfettered choice of lawyers does not make sense. I think the takeaway from that is clarity and simplicity needs to be paramount in the way that we deal with things. Oh, and now over to what everyone's really waiting for. That's Peter to tell us about PACCAR and the CJC review. So over to Peter.
Thank you, Gordon. When the courts decided in PACCAR that litigation funding agreements were effectively damage-based agreements, I'll refer to them as DBAs going forward, the funders tried to navigate themselves away from the share of damages model to being rewarded by payment of a multiple of the amount of funding. However, this is now under scrutiny too. Sony and Apple are currently arguing in the Court of Appeal that even these agreements should be regarded as DBAs. And this is part of competition litigation where valid funding arrangements are almost the prerequisite to bringing a claim. And if the Court of Appeal decides that these agreements are also DBAs, then this again was going to affect a wide number of other agreements that have been used to really almost sidestep the effect of PACCAR. And in fact, the CJC report, which I will come on to shortly, recommended to the government that funding agreements should include both those that take a share of the damages as well as those that use a multiplier of damages. So the CJC report is not binding on the courts at the moment. Obviously, it's only a recommendation to the government, and thus far the government have not said more than that they will outline the next steps in due course. It is said to be possible that the Court of Appeal will hand down this judgment before the end of July when the courts break for the summer. And this may tie in nicely with the reversal of PACCAR, which the CJC recommend is prioritised in its recent report at the beginning of June. So, however, what we do know is that the law is supposed to eradicate uncertainty, and hopefully the government and the courts will act swiftly one way or another.
So now we're going to turn to look at the future. Don't worry, there's plenty more of Peter to come. And here it's, well, the girl that's driving me mad is going away. So is PACCAR going away? And in this section, we want to look at the CJC report and think carefully about whether overall this is going to allow more room for insurers to expand their product base, or whether there's room for collaboration with funders of a greater degree. So now back to Peter to look in more detail at the CJC report.
Thanks, Gordon. So on the 2nd of June, the CJC published its final report on its review of litigation funding, and this was 2 months ahead of schedule. The report was commissioned in the wake of PACCAR and to address the issues and disruption caused by that decision. Now, the fact that the CJC has issued this report ahead of schedule is quite telling, we think. There's been a lot of uncertainty and turbulence in the funding industry since the PACCAR decision, and the industry has quite rightly been described as being in a state of limbo. And in PACCAR, the court ultimately determined that funders provide claims management services, because this includes financial services or assistance, even when they're not directly involved in managing a claim by lawyers. As we touched upon, the PACCAR ruling obviously had significant ramifications for UK litigation funders, as well as claimant law firms who rely on them. And for those cases that were already underway, funders found themselves rushing to replace existing funding agreements. However, for those cases where proceedings were ongoing for an extended period, funders were facing significant losses for recovering that historical legal spend, given the LFAs were already in place, were deemed to be invalid. And indeed, the Supreme Court noted in PACCAR that the majority of the LFAs in force at the time were likely to be unenforceable, or at least partially unenforceable, so far as the payment provisions were concerned. And then in terms of the future claims, funders were forced to reconsider the types of claims they were willing to fund and their attitude to risk going forward, given the concerns on their return on investment. So this basically would mean that more speculative claims would struggle for funding. And there was also even mention of previously funded parties that paid a portion of their damages to a funder, potentially seeking reimbursement of that sum from the funder. But now going back to the CJC report, they've made a total of 58 recommendations, and they cover almost all aspects of litigation funding. The report's primary aims are, understandably, to promote accessibility to justice, ensure a fair and proportionate regulation of third-party funding, and also to improve the transparency of litigation funding. Now, we don't propose to cover all of the CJC's 58 recommendations here, but we think we should summarise some of the key ones, or the ones that we think are certainly quite key. And the first one is no surprise that the number one is reversing PACCAR as soon as possible. The CJC are calling for urgent legislation to be introduced, confirming that litigation funding is not a DBA. It should also make clear that litigation funding is not a form of claims management service, as we mentioned earlier. But crucially also, the legislation is to apply retrospectively, so it can put right that turbulence that was caused in the aftermath of PACCAR. Secondly, litigation funding is now, well, already is, but will be subject to more formal, comprehensive regulatory a scheme to cover all forms of litigation funding. So there will be more regulations in place in respect of this funding, and there will be an end to that self-regulatory approach, albeit the CJC described this as a light-touched regulation. And I think that, just touching on some of them, this will include things such as conflicts of interest provisions, prohibiting funders to control the litigation, capital adequacy requirements, early disclosure of the existence of funding, and anti-money laundering checks. And I think one point to highlight here is that the CJC has not opted for that heavy-handed regulation by the FCA, but it recommends the position is reviewed in 5 years if this light touch approach is not working. Thirdly, for those funding of class actions and consumer claims, there will be more extensive regulatory requirements. And this is with a view to providing greater protection to vulnerable consumers and changing how claims are currently incepted. For example, here funders will be subject to a regulatory consumer duty. Independent legal advice from a KC is to be given before entering into a funding agreement. And the funder or funded party's lawyer is also obliged to certify to court that they did not approach the funded party to pursue those proceedings. Now, regarding this latter point, it's a relatively common occurrence for funders or lawyers to search for parties willing to start a claim. Some may refer to this as the ambulance chaser culture over the years, and by introducing a requirement where formal certification needs to be provided by the court with a likely accompanying statement of truth, then this will hopefully prevent these unethical and aggressive ways of offering legal representation to potential claimants. A further key recommendation is that there are to be no caps on funders' fees or return. Now, for consumers and group actions, however, protection is provided by a requirement for the court to approve the level of funders' return as being fair, just and reasonable. So this will not simply be an unlimited return, it will be subject to scrutiny. Cost budgeting and cost management are to be mandatory for all funded collective proceedings and group actions. So there will be better practice guidance on cost budgeting, and the management of funding claims should be developed. And also the recommendation is that only specially authorised judges with specific training will be allocated to manage funded claims. The next key recommendation is that litigation funding costs are to be recoverable in principle, but recovery should be confined to exceptional cases. So that's taking into account factors such as the defendant's conduct, the claimant's financial position, and the necessity of litigation funding. Now, interestingly, the report also recommends that funding in arbitration proceedings is not to be subject to these formal regulations. So it will be for the arbitral centres to determine whether and how that should be implemented. And by choosing not to impose formal regulation on funding in arbitration, we think the CJC may, in a sense, be preserving the appeal of arbitration as a flexible, party-driven and alternative dispute resolution forum. And avoiding those stricter rules faced on the funding in court proceedings could make arbitration a more attractive option for commercial funders. And finally, in terms of legal expenses insurance, the CJC have referred back to the recommendations in the Jackson Cost Review, and they are promoting the use of home insurance and a greater uptake of those BTE policies. This again, we think reflects the drive for those potential claimants to have that accessibility to justice. Now, the CJC's final report sets out a very good foundation for forward-looking reform and regulation of litigation funding. In terms of next steps, the report will now be considered by the Lord Chancellor. Now, with the exception again of the recommendation for the reversal of PACAR, which the CJC propose is prioritised as a matter of urgency, we expect the CJ's recommendations, if they are approved, to be implemented through a single comprehensive statute. And I think the challenge here lies in whether the government embraces the recommendations, and how quickly it acts will really determine its true impact. Any further delays obviously risk prolonging this uncertainty in the market and the funding of cases. So ultimately, what the CJC are seeking to do here is strike that right balance between a wider access to justice and commercial viability and incentives that drive funders. Funding will be more consumer duty focused, but it will also limit the constraints on funding, especially those imposed by PACAR. Now, that said, whilst the report may have restored some confidence and encouragement to funders, there is no doubt there will be some further regulatory requirements or hurdles for them to consider and comply with. For example, the capital adequacy, the cost budgeting, not being allowed to approach those potential claimants. Inevitably, this will lead to funders reconsidering their strategy and approach to risk in litigation. We expect funders will be maybe more selective and take a more targeted approach towards the type of cases they invest in because of the more stringent measures there. For example, they will be more cautious of reputational risk due to the increased transparency requirements. Funders may only be prepared to back cases with higher potential damages due to the uncertainty. And the strong prospects of success bar could be raised even higher now, given the KC advice requirement for class actions and consumer claims. And this may well leave claimants seeking some alternative funding, such as AT and BT insurance. Now, whilst AT and BT insurers may not compete with funders in all areas head-to-head, the CJC's proposals could expand their influence and market share. It may also give a rise to the alternative covers of products referred to by Gordon earlier, such as WIP protection and capital protection. Finally, it's important really here not to lose sight of the bigger picture in times of uncertainty, and we seem to be going headlong into such time. There's often an increased activity in legal matters as society seeks certainty even more than ever. LEI and funding inevitably may be called upon more and more. And in particular, with the effect of social inflation and the heightened feeling that large corporates require reining in, there may be more class actions, which is, of course, another fertile ground for funding. Now, I'll hand over back to Gordon.
Yeah, I just wanted to finish off this section by looking at a couple of matters. First of all, the effect of the new fixed cost regime on the legal expenses market. The new fixed cost regime applies to all claims up to 100,000 and is about to be extended at some time in the relatively near future, we feel, to £250,000. And that deals with quite a big swathe, I would have thought, of claims that fall to be dealt with under legal expenses insurance. And the fixed cost regime should give us greater certainty for the limits of costs for which the litigating party might be responsible. And I wonder if it's going to help with the applicability and the underwriting of legal expenses insurance covers. Budgeting is the other thing that I wanted to mention. What I'm talking about now is the need for lawyers to budget and project plan their cases rather than just budgeting within litigation, which is still a bit of an adversarial process. whereas budgeting for the whole claim and project managing it is something that clients should be asking for in nearly all cases. If budgeting is done on a realistic basis for clients and also therefore legal expenses insurers and funders, then the better the support will be for the access to justice that clients need. And that's, I think, a heavy responsibility on lawyers who look to use these facilities. And lawyers are under increasing pressure to advise the clients on costs at all times. And in Andrews versus Berg, it was recently held that a solicitor owed a general duty to discuss with the clients how litigation is to be funded. And that's a duty that I think is going to be seen to be enforced much more through the courts in the next few years. So a greater ability to succeed in budgeting and project planning should make lawyers more efficient and more successful and able to survive, and make it easy to work with providers of funding of all sorts, which must be a win-win-win situation. Just coming to the next slide to look at takeaways and themes for the future. Some thoughts in summary. To achieve a wider access to justice than any imbalance of regulation between LEI and funding that's not explained by the more vulnerable nature of the consumer of such services will need to be addressed. And I think the CJC report's done that to a degree. Interestingly, however, the CJC left a general question of regulation as something to come back to in 5 years' time. So let's see how that unfolds. Now, legal expenses insurers and funders already have some interplay. ATs are often an essential part of a funding package. But is there room for greater collaboration between the sectors? Is it possible to provide for all this under one umbrella, bearing in mind the wider responses to PACA that have arisen with the use of alternative solutions? Does PACA and the CJC give LEI insurers a greater area for growth and to see more policies being sold? And I think that's quite possibly the case. What's important throughout all this is that we have accessible policy wordings that lack ambiguity and are clear. And this must be paramount in the extension of the LEI product. To gain better results and better market share, it's essential to be open and transparent on process as well, in particular in relation to prospects of success. A consumer-orientated claims service must be and must remain in place. And solicitors need to play their part in this. They must be able to communicate better with legal expenses insurers and be able to budget and project plan claims more effectively. Legal expenses insurance should not be a crutch for supporting the old ways, but should be an accelerator for the adoption of more modern, efficient working practices. So if Lord Justice Smith were to opine in a similar way to that which he did all those years ago today, would he reach the same conclusion? Would he conclude that the LEI funding market is not managing at all well? Well, I don't think so. I think he'd see a market that's become more sophisticated, that apart from PACA has largely stayed away from disputes in court. There are not so many reported cases about legal expenses covers. And it's on the brink of being able to achieve even more, with a little help from its friends. But then that's another Beatles song altogether. Thank you very much for listening to us. And now there's a chance for us to deal with any questions and a discussion that's been raised on the chat as we go through.
Right, thank you very much. There was, yes, lots of information there. And for those that were aware of the Beatles song and the lyrics, there was constant reference to that one as well. I have a question on the chat for you, and we've also got a couple that were submitted earlier, so I'll do the chat question first. Do you see the SRA having an interest in regulating litigation funders in conjunction with the FCA?
I think that, well, I'll ask Peter his opinion again in a minute because he dealt with that CJC part of the discussion. The SRA are undoubtedly want to going to make that look at how solicitors play their part in the funding scheme of things. So they'll need to look carefully about the regulations that are applied to funding and make sure that they're also responsive. Don't forget, though, that SRA regulation is objective based. It's not so much specific to particular things. So they'll have to work out the objective actions and behaviours that they want to enforce and see how they apply to this kind of activity that lawyers become involved with. But I think it's inevitable they will pay attention to that over the next few years. Peter, do you think so? That's right?
Yeah, I think that's correct, Gordon. And just going back to the point about transparency, and it is not only recommended that the funder kind of provides that assurance that they haven't approached potential claimants. It's also the law firm as well. And, as we know, there are many claimant law firms out there who do that. I had a very big case in Africa where at trial it came out as to how they had approached these claimants, and they want to stamp down on that. So, I think the SRA as well, obviously will look, quite foully on any breaches in that respect. So there could be a conjunction there.
Thank you. Are you ready for your next question? So this one is looking at LEI, get the acronym right, products in general, and asking about public awareness, and it's still relatively low. And what practical steps would you suggest for providers to take to try and address this?
Well, I think that certainly looking at the routes by which the product is bought, the CJC obviously want to look at attaching it to even more property covers. We see it obviously in other covers too. And I think it's important that we think about that as a useful add-on to other covers and sell it as something that's really useful. It's a bit like having, I shouldn't make the analogy of it, it's a bit like having a pet insurance. You get a dog, you think about insuring it because something may go wrong. And so why wouldn't families think, if the premiums are right, that they should think about BTE covers and looking for policies that give that as an add-on? Because who knows when you're going to get involved in some dispute that you need to deal with. So I think some kind of social advertising, pressing people to think about how important it is, and more importantly, making it as accessible as possible. I was just asked to review a legal expenses wording as part of a wider policy offering. And I think I reduced the pages of the legal expenses part of that policy from 5 to 2 to 1.5, almost 2. There was so much in it that was overcomplicated and we didn't need. And I think making the products as accessible as possible is really important.
Thank you. And another question, looking at what do you find the most common types of complaints that are seen by the Financial Ombudsman Service?
I think it's worth, just retracking over what we said earlier. I think the two real areas that spring out are, again, about the prospects of success and choosing own lawyers. Those are two things the consumers are very concerned about. And I think the prospects of success is a particular problem. I've dealt with a number of cases, both for insurers and the odd one on the other side of things where we're doing recoveries, where there's been really difficult prospects of success to establish. And I think making sure that the buyer understands how that process works is really important. So it needs to be transparent and easy to access. And although I suspect some of those complaints are from aggrieved insureds who believe they've got the God-given right to go to court no matter what, a lot of them will be because they don't understand the process or it's not been well administered by their own lawyers. And then that's another area of education that will help with those complaints. And I think those are the two main areas that I'd focus on about the areas that give rise to problems as far as FOS is concerned.
Thank you. And now looking at, in terms of the regulations recommended by the CJC, what potentially is the outcome or consequence of any breach?
Peter?
Yes, I'll take that. Thank you. I expect it will render the funding agreement unenforceable, again, as against the funded party. So to an extent, the concerns following the previous PACCAR judgment will return to an extent. But this also, I think, brings about some possibility of satellite litigation, because I think funded parties will feel aggrieved. They may seek to avoid their contractual obligations by perhaps alleging that they suffered a loss because the funder didn't comply with the regulations. And I think, as we touched upon earlier, those regulatory requirements will still be playing on funders' mind and may well act as a disincentive still, in the fear that they may be caught out perhaps by these additional regulatory requirements.
Thank you. I've got one last question, so I don't know who will be the lucky recipient on the panel. So this one is in reference to consumer duty and asking how will this principle, or how do you think this principle will be applied in practice?
Well, I think I will probably both have a go at that. But for my part, I think, although I hate necessarily to be a typical lawyer, I think it's the time to sit on the fence and say we just don't know. It's going to be difficult to work out how the consumer duty applies in a pure funding situation as opposed to legal expenses covers. But what I think we will know is that it's something that's going to be looked at very carefully. But which way it's going to go, I think it's really hard to say at the moment. I don't know how you feel about it, Peter.
Yeah, no, I think it's a good question. I think part of the problem I envisage is that the third-party funder is quite removed from the individual consumer. They're not involved in the day-to-day management of proceedings. And if there is going to be a recommendation by the CJC that is accepted, that they obviously subject to this consumer duty, how will it work in practice? We've got to be, it's easier when, you have access to that consumer and ensure you can comply with that duty. But, if they are removed from the case in a sense, then, they've got maybe need to be tweaks there in terms of how they put it in practice.
Thank you very much. And I think we've got, I know, we haven't got any more questions popping up in the chat. But what we have done is timed it perfectly. So we've just got 1 minute left to thank firstly the panel. Thank you to Rachel, Gordon and Peter for sharing your knowledge and for your time. And yes, thank everyone for joining. And as I always do at the end, I will send out even a request for feedback. So really, please do fill that in, because it does help us shape how we put these sessions together in the future. So yes, thank you to everyone for joining, and enjoy the rest of your day.
And thank you from all of us. Thank you.
Thank you.